Yes.
Adjournment request from item number 1 to 11.
May I praise your lordship? Lordship, I am referring to item number 3.
Yes.
A kindly short accommodation may be made. Actually, we don't have the brief right now. We have been recently engaged.
As on behalf of the appellant.
Yes, on behalf of the
But the appellant is the Director of Education, who
Director of Education, BTC.
has prayed for on behalf of the appellant pre-notify after 2 weeks.
Lordship.
With your lordship.
11
With regard
February.
to item number 11, your lordship, I appear on behalf of the private respondent, the lordship.
11, you have,
Survey adjournment slip, your lordship.
all right. You are for the private respondent.
For the private respondent, the lordship.
Inform the other side of
Lordship of submitted.
March.
6 March.
Please, your lordship.
6.
Lordship, I beg to mention item number 9. The conducting counsel is in bereavement. His father expired.
9,
Yes, your lordship. I am on behalf of the appellant.
as prayed for on behalf of the appellant pre-notify. So and so date. That is that Sakhi one-stop center.
16 March. From item number 12 to 22, adjournment request.
My lords, in item 18, we have circulated a slip.
No. All right, again in March.
Apply.
18 March. From item number 23 to 28, adjournment request.
Lordship, item number 17 may be
17.
listed before
Louder.
the appropriate bench.
Louder, you have to be a bit louder.
17.
Lordship, item number 17 may be listed before the appropriate bench.
Item number 17, we will not hear it. All right. Item number 17, let this case go out of our list and be placed before an appropriate bench, of which one of us, Justice Arun Dev Chaudhary, is not a part. Place this case before the place this case in the administrative side before the Chief Justice for allocating an appropriate bench. All right.
May I please, Malak?
Hmm.
Malak, I beg to mention item number 25, Malak.
25,
Yes, Malak.
adjournment slip has been served. All right.
18 3.
May I please, your lordship? With the consent of the petitioner, I beg to mention item number 26, lordship. Today, my senior Mr. TJ Monto has some difficulty. After 1 week, lordship.
As jointly prayed for, re-notify, give a date according to the calendar.
Next week, my lord, if it is convenient.
18 February.
My lord, please.
Oblige.
May I please, your lordship, my lord, I beg to mention item number 15, my lord.
1-5.
1-5, my lord.
Hmm.
Lord, one chance may kindly be given, my lord, some difficulty today, my lord.
Constable selection of the year 2000.
My lord, my lord have already heard and a detailed order had also been recorded, my lord. My lord, one chance.
At the request,
My
at
lord.
the request of Mr. Bhuyan, you are which Bhuyan? AR.
Yeah.
My lord.
At the request of Mr. AR Bhuyan, let it advocate for the appellant. The matter is adjourned to, then we send it to April.
Can it be on last part of
March.
well,
May I
Oblige.
please, your lordship? Your
25
lordship,
3.
item number 18, your lordship. It
Yes.
has been mentioned, your lordship. We have give consent also, your lordship. They are supposed to file it within 2 weeks, your lordship. Now your lordship has fixed it in the month of March. Can it be in the month of February, your lordship, second half?
We don't have.
We have some urgency, your lordship. That's fine, your lordship. And in fact, I have consented since he says that within 2 weeks we will file our affidavit, your lordship.
What date we have given? Early March.
18 3.
No, give it early March.
Early.
March.
Lords. Oblige.
We
6
will
March.
ensure that your case does not fall with the Ides of the March. Much before 15.
6 March.
Lord.
Inform the other side.
I will.
Any other request?
May I please, your lordship? Lordship, I beg to mention with respect to item number 30 of the supplementary list.
Item number?
30. Lordship, we have filed an affidavit yesterday, your lordship.
Hmm.
That is not on record, your lordship. That may kindly be called for, your lordship.
Please bring that up.
Lordship, here is a small
We
request
can-
as well, your lordship.
We can list it for tomorrow. The report has to rise early.
Lordship, if possible, on Tuesday, if your lordship convenient.
As prayed for on behalf of the appellant applicant re-notify next week.
27, 27, 1.
Deeply obliged.
Any request? Daily list for orders item 1.
Yeah. Service to? Oh, 6 to 26. गलत लिख दिया है. 6 to 26 is the first order. Yes.
No, please, your lordship. There is a delay of 121 days has taken place.
6, 7, 8. There is no report regarding service of notice on response number 9 to 26.
Your lordship, regarding this, I beg to submit the matters between the court and the petitioner counsel, advocate counsel. Now, is it necessary to serve notice upon the respondents, other respondents?
Cost imposed upon the lawyer. Anyway, we condone the delay. Take down. Respondents number 9 to 26 have not been served. There is no report. There is no report regarding service of notice on respondents number 9 to 26. There is an application seeking condonation of delay in preferring the appeal against an order in which cost has been imposed upon a lawyer.
Lordship, I'm representing respondent number 6 to 8 here.
Considering this aspect of the matter, where the presence of respondent number 9 to 26 may not be necessary, we direct for listing of this case under the appropriate heading. No, it's unnecessary. Stop. We have gone through the application seeking condonation of delay of how so many days. Finding good grounds, we condone the delay and allow this application, the appeal to be processed and listed in the listed on your date in March.
On behalf to the
Highly observed.
Well, marked.
highly obliged.
Item 2.
Well, item 2 is similar to the writ appeal 287/2023. My lord, please to
You have yet not filed the affidavit regarding the service. Why did you do that, Mr. Katnia? Why don't you, have you served Dasti?
yes, my lord, does
Where is the affidavit that you have done it?
that, my lord.
File an affidavit
Yes, my lord.
next week, and then we do whatever we have to do.
Yes, my lord.
Mr. Katnia, learned counsel for the applicant, submits that by the next date, the affidavit regarding Dasti service of notice on respondent number 1 shall positively be filed in the register. List this matter on after 1 week. We did.
Obliged.
9 February. 9/2. Item number 4.
Has any date been given in those appeals?
My lord, yet no information, my lord.
Please have that information. No, we will place this review petition along with those appeals.
Yes.
It's a common judgment. If you tell us today, we'll fix it today.
Yes,
You have to tell us, no?
Yes, my lord, but I will, my lord, during the day.
So I'm passing it over for the day.
Yes,
The matter will come again tomorrow.
Yes,
You find out and tell us.
yes, my lord.
All right. This has to be your effort.
Of course, my lord.
And Mr. Katniar, you also confirm that these are the appeals which
Yes,
are to be listed. If there are no dates given, we will have it on the track.
Yes, ma'am. Tomorrow.
My brother says that date has been given in those set of appeals. Correct? Tomorrow. You pass it over. This matter tomorrow. Okay.
Item number 5.
Yeah. नहीं ये इसके लिए 612 days. क्या है? But he's not in the picture. No, we dismiss this. We dismiss this application. There is no good ground. 612 days.
612 days, my lord.
The application,
There are some other.
application is rejected.
Obliged. Highly obliged.
Mukut. Take it.
Item number 6.
Lordship, the matter may be passed over for the time being. Mr. Dinath, he is on his way, Lordship. He's on legs in another course. It may be passed over for the time being, Lordship.
We are not inclined. Therefore, we will not saddle it on you. Let your senior come.
Lordship, he is coming, he is on his way, Lordship.
Who is your senior?
Mr. Dinath,
You call it after 2 cases.
Lordship.
Item 7.
ठीक है. Notice है? Mr. Khatniar,
Yes,
accept notice.
yes, my lord. On behalf of 1, 2, 3,
4 has to be. Like, there's an application seeking condemnation. For details, let notice be issued to the respondent. Mr. Khatniar, learned, he's the standing counsel. Standing counsel accepts notice on behalf of respondents number 1 to 3. Let notice be issued to respondent number 4 on steps being taken by the applicant, appellant applicant, within a period of 2 weeks, both modes returnable on so and so date.
16.3.
obliged.
Obliged. Lordship, can it be in the month of February also? There is some urgency, Lord.
Make it 1 week. Requisites within 1 week and then in February.
25.2. Item 8.
First time. Reject it.
May it please your lordship.
I'll reject it. Now,
Lordship,
this application should have been rejected. I mean, should not have been listed. You have left every, you have given the fill up the blanks to us. How many number of days? What has happened? Nothing.
lordship, there's a 106-day delay.
We are rejecting this application, giving liberty to you to file a fresh application. This is not the way.
Lordship.
For the reason of
Oh.
the application for condemnation of delay being defective, we reject the same, but with the liberty to the applicant to file a fresh application for condemnation of delay.
Supplementary list for orders, item 29.
Due to amend it, but this is not done. 2 pages, 2
Lordship.
pages affidavit. If you don't file it properly, then
Lordship.
we are not happy.
Lordship, I apologize, your lordship. We'll file a fresh.
Item 29. Supplementary list.
Yeah. No, we had directed it to be listed for admission.
admission.
Why has it come for orders?
That your lordship registry will know.
I will do it after 28. This case was directed to be listed for admission as the service of notice is complete. List this matter under the appropriate heading on, give a date on 28th. Is there any urgency? So we will
Lordship, we have some urgency.
on
since-
28th of January.
Lordship.
Number 32.
Daily list for admission, item 10.
Okay.
May I please, my lord?
Yes.
My lord, page 90, my lord, that was the first order, my lord, which was passed. May I read that order, my lord?
No, tell us what is the matter.
The matter is, my lord, the single judge has passed an order which ultimately makes the entire order infructuous. He has
What has happened?
my lord, what has happened? My lord, may read up I'll take up the page 101, my lord. Impugn order, my lord.
Page?
101, my lord. There are penalties, my lord.
But this was modified, no?
My lord, when this is modified, ultimately it results to no penalty.
Why?
My lord, may read para 11, my lord. Under the facts and circumstances of the aforesaid, this court is of the opinion that the penalty imposed be restricted only to withholding of increments for the period in question without cumulative effect. And the first part of the penalty of the reduction to the lower stage in the timeline of pay of one stage for 1 year stands interfered with.
Yeah, that's right, but then this is basically on the merits of the case.
No, my lord.
Do you contend that the single judge did not have the power to do so?
No, no, my lord. That is not my submission. My submission is that when we apply this order, ultimately no penalty is being imposed.
No, I don't think so.
No, only that
How-
observation.
You build up this point. We are not finding this submission to be correct factually.
No,
and legally.
I'll show, my lord. I'll show that. I'll show that. My lord, may I kindly first come to page 90.
No, I mean, we need not go into those details. Let us see only with respect to penalty. The argument raised on behalf of the respondent was that these are two penalties provided under 67, Rule 67 or something. So this could not have been combined and two penalties could not have been given.
That is an incorrect observation. I'll satisfy, my lord. That is an incorrect because he was not penalized in that two provisions. He was penalized in F, 67F. The observation of the court itself is wrong. That is why I wanted to come up with the orders which was originally passed.
Show us.
My lord, may come up first to page 90, which was the first order. Last para, my lord. Reduction to a lower stage in the timeline of pay scale by one stage for a period of 1 year, with further directions that the officer will not earn increments to pay during the period of which reduction or on the expiry of such period, the reduction will have the effect of postponing the further increments of pay in terms of 67F. Now, my lords, they filed an appeal and it was modified. The appeal order is 93.
Mr. A.K. Sahewala, London advocate for the appellant / State Bank, na?
My lord.
State Bank,
State Bank.
who has questioned the judgment impugned on the ground that with the interference in the quantum of sentence, allowing the conviction, allowing the finding of guilt to remain intact, the sentence has become nugatory, as if no sentence has been passed, no punishment has, the punishment has been rendered nugatory. Let notice be issued to the sole respondent, on the steps being taken by the appellant within a period of 1 week, both modes, 2 weeks, both modes returnable in March.
My lord, the stay of the impugned order, my lord.
It's not required. No?
My lord. Grateful, man.
23, 28 March. Timing metro 620.
Bid number 6.
Well, the IA is for condonation of delay in filing the appeal.
Mr. Nath, we are not in fact. Look at the issue.
Well,
Look at the issue and what is the ground?
Well, the date of birth has been recorded on the basis of horoscope. While the kindly come to para 4 of the writ petition, that is his case. Can you see, for a moment, he said, page number 21 of the appeal memo.
No, but forget about the merits. Why do we interfere for this delayed application?
The delay.
What grounds have you said except the administrative lethargy and all?
The delay I have
Let's see
explained.
the judgment first.
Standing counsel was there at that point of time. Ultimately, file was handed over to us. And while processing the records, otherwise, kindly see HSLC certificate as per it is his case that as per HSLC certificate, his date of birth is 1953.
Give the records. Just, I'm not. Has he annexed it?
I'll take your lordship to the judgment, but first kindly come to page 21, my lord.
Just a minute, just a minute.
Lordship, lordship.
सर्टिफिकेट नहीं देखा, कुछ नहीं देखा, केवल the judgment appears to be, I mean, we do not prima facie find any reason to sustain this.
My lord, the estate,
Otherwise, delay has not been explained.
my lord,
This is caused, I mean, after retirement, what grounds have been taken and then recovery has been ordered.
Yes.
No. For the reasons stated in the application. We have heard so details later. The application is allowed, the appeal to be processed.
All right, my lord.
16 months. Item 12.
Yes,
May please, by this impugn judgment, my lord, do you
but can it be done? He's right. He's right. Let notice be issued to the respondent. That's right. I mean, the single judge could not have asked the Assam Electricity Grid Corporation to do something which was not allowed.
No. Impugn order kindly judgment may be stayed, my lord. Otherwise,
No, we'll let. Take down. The respondents are junior engineers appointed in the year 2004 by the Assam State Electricity Board. They challenged their placement under the new pension scheme and prayed for their coverage under the older defined benefit pension system or the Central Civil Service Pension Rules 1972. The APDCL and its authorities contested and took the stand that the new pension scheme applies to the respondents as per their appointment terms and internal policies. The APDCL and its authorities are not bound by every central or state government rules. The learned single judge appears to have directed for consideration of the case of the respondents for giving them one-time opportunity of switching over to the old pension scheme, if so desired, on the sole ground that such concession was given to central government employees at one point of time. The land council for the appellant submits that this was beyond. Lead counsel for the appellant therefore submits that the judgment is not sustainable in the eyes of law. Let notice be issued to the respondents on the steps being taken by the appellant within a period of 2 weeks, both modes returnable in April. Till such time, the operation of the impugned judgment shall remain in abeyance.
Second April, 2/4. Item 13.
My lord, in this similar matter, there is already an order, my lord.
Any cases pending?
Yes, my lord. So, I'll do it.
Can we have that order?
Yes, my lord.
Lordship will find it at page 145 of the
146, the order starts, my lord. And the operative
146.
portion of the order is at page number 149. Please come to 148, my lord, para 10, 910. Thus, from the submission made at the bar, it is not in dispute that land acquisition compensation has not been disbursed to the petitioners. Therefore, condition precedent for taking
The
possession
cases,
of
the
the-
facts are same, Mr.
Yes.
Porpujari?
And in fact, at page 157, the earlier order was extended by this honorable bench, my lord.
Okay. Let this matter be listed along with WPC number 6172 of 2025, where similar issues have been raised. On so and so date. On 29/1, also, it's coming now. On 29/1/2026. Till such time, the respondent shall not be, till such time, the appellant shall not be evicted. Anna?
only with regard to possession.
They shall not be dispossessed.
Disposal.
They shall
Otherwise,
not-
my lord, everything is complete on paper. The acquisition
Let's see.
exercise is-
Let's-
My lord, I'm sorry.
My lord, this 64 acts to repeal.
Anyway, we'll see it on 29th.
I will defend.
I- Item number 14.
Lordship, in this case.
Please, my lords, we are here. My lords, a very
Yes.
happy new year, my lords. May I just start? My lords, if you recall, in this matter, my lords may see your order dated 24/11/2025. And that is the last date on which it was listed. And my lords had issued notice and asked, my lords had not issued notice, but had asked them to give an affidavit in this matter.
Wait.
And if my lords will recall,
You're not visible. You're audible, of course, but you're not visible.
I apologize for for that, my lord. I think there must be some problem. Please, my lords.
Yes. Now
Yes,
you're
yes,
now you're visible.
Yes. My lords, we are wearing the invisibility cloak as counsels, the invisibility gown.
Visible. That's you. It could be a cloak for you, but then we do not permit only audible without video, not knowing that the lawyer is at an appropriate place or the lawyer is in his garb.
Yes.
Mm.
My lords, in this matter, my lords had heard us substantially on the last date and had asked the state to give an affidavit giving all the details of the compensation scheme, if my lords will recall. But I'm happy to take my lords through the matter once more.
No, Now let us see, the learned advocate general is here to say something, just. pour him
Lordship,
out.
we have communicated with two districts which are involved. One is Morigao, one is Nagaon. The deputy commissioners are collating all the records because this belongs to 40 years ago. So they are very soon, they are submitting all the records.
But
Once we receive,
did this bench ask you to do that?
and if it is requested from this honorable court. If that is not required, but in the meantime, there is another development. A report has been submitted to the State Assembly also on the Nelli massacre.
Okay.
In the recently, hardly.
Something 40 years old.
Yes, Lordship. That report was not submitted by the earlier governments. The present government took that risk and brought everything to the Assembly. I have requested a copy of that also for my perusal, and if you could, I will.
All right, collate all information and
Yes.
then
Maybe after 6 weeks,
after 6 weeks, MS Farasat, I
Yes.
think something positive appears to be coming.
I
Let's-
hope so, my lords. My lords, like we say in Hindi, aapke muh mein ghee shakkar. My lords, may I only request one thing, that my lords may please make this matter part heard. For the
No,
simple,
that we don't do. In my 12 years of judging,
Yes.
we have not done this.
yes,
If,
yes.
if the matter is so urgent, we'll give a hearing on day-to-day basis, but I don't keep any matter, parted.
My lords, may I only, my lords may refuse my request, but the only difficulty is that if my lords will recall on the very first date when it was listed before this
That's all
bench,
right. That's all
my
right.
lords had heard it extensively, then it goes to another bench. So my lords, please keep it with
No, this-
yourself. That's my request.
But you see, you got a lease of life. We had asked you to go before a single judge, if
Yes,
if
my
you
lords.
remember.
Yes, I'm grateful for that lease of
I
life,
did
my
not
lords.
remember this. My brother has reminded me of this.
I am grateful, my lords. It's a new year, so we all have a new lease
All
of
right,
life.
so let us wait for the collated
right.
information and then we'll see.
All
In
right,
fact,
my
I would like
lords,
to make
may
one
only
thing
fix
clear.
a date. May only fix a date so that
We will. Yes.
yes,
Yes,
yes.
that report which has been submitted to the Assembly, it has nothing to do with this PL. It is not an outcome of this PL
All right.
or a
We are
knee-jerk
not saying
reaction
that.
of this PL.
We are
No,
not
no.
saying that.
No,
We are
it's all
not
right.
saying that.
Here, the learned advocate general has submitted that information regarding the Nelli massacre is being collated from different districts, and a consolidated response affidavit shall be filed by the next date.
Lordship,
Be notified. Give us 8 weeks.
Lordship, highly
Fix a
obliged,
date.
Lordship.
8 weeks.
My
Deeply
lords,
obliged.
sometime in March.
Now, March would not be.
My lords, may I request March? I'm only requesting March. Any time, even towards the end of March, but March, please.
All right, 27th of March.
I am so grateful, my lords. Very
It will be
grateful.
1 day
Very
later,
grateful.
Lordship.
1 day later.
Yes.
So 28th is a holiday.
Then
So we
then
can give
30th.
30th of March.
30.
30th of March.
So grateful, my lords. Very grateful.
Highly obliged.
Item 16.
May I please, Your Lords?
Yes.
Lordship, here, my lord, the Honorable Single Judge has closed the matter, my lord, on the ground that, my lord, I have written.
Louder.
Honorable Single Judge has, my lord, closed the matter, my lord. On the ground that, my lord, I have retired in the year 2012 when no purpose will be served, my lord. If, my lord, DPC will be held and I will get notional benefits.
I think the judge was absolutely right.
My lord,
I'm only thinking of the reason why cost was not imposed.
my lord, I am entitled for the notional benefits, my lord.
Nothing. The appellant has questioned the judgment dated 7/1/2025, passed by a learned single judge of this court in WPC number 7297 of 2013, whereby it has been held that any order passed on the facts of the case would be a futile exercise. The appellant had earlier approached the Assam Administrative Tribunal, Guwahati, seeking a relief of direction to promote him to the rank of Additional Chief Inspector of Factories with effect from 13/10/2004, notionally, as he had already retired,
At that time, I was not retired.
notionally. The Assam Administrative Tribunal rejected the prayer of the appellant. The records reveal that the appellant had earned adverse remarks in his ACR for the years 2002-2003, and therefore he was not recommended to be promoted to the post of Additional Chief Inspector of Factory. He had challenged such non-consideration by the writ petition bracket WPC number 854 of 2008, wherein some observation was made, challenged in WPC number so and so, which was disposed of, but with a parenthetical observation that the adverse remarks recorded in the ACR of the appellant for the years 2002-2003 were not in consonance with the ACR rules. However, the learned single judge refused to interfere in the matter, and in our estimation, rightly so, for the reason that the appellant had already retired in the year 2012. And if any order had to be passed, it would have been in the nature of a direction for holding a review DPC, which was neither possible, nor feasible, nor advisable. The learned single judge therefore observed that any order passed in the present set of facts would be futile, Placing our imprimatur on the aforementioned reasoning, we dismiss this plea.
Item 19.
Iter vita.
Made a lawsuit, madam. But your lawsuit, so that we have filed a reply long back.
We have filed affidavit on 24/9/25.
And we filed a reply to that also.
What have you said? We'll come back to your reply. What have you said?
In paragraph 6 of our affidavit, we have said that particular place.
Take us to that page.
Yes, page 60, 60.
60.
Yes, as a running page 60.
0, no?
Yes.
But para 6, 8, 14 and 20 are important.
Read those paragraphs.
Yes, Lord. The deponent denies that the dumping is not.
No. Page 60 is that with regard to statements made.
Yes, Lord. That with regard to the.
Yes.
That the deponent denies the same and states that the dumping is not done illegally in the area. The aforesaid area of land has been handed over to Howli Municipal Board by the land revenue authorities for construction of material recovery facility. Also, material recovery facility and composite pit project will be constructed at the site where all the waste will be processed and remediated. The land is not an open dumping ground, but a project is going to be set up for waste processing and treatment. Then kindly come to para 8, Lord. We have said that they have not the correct information, or they are trying to mislead the honorable court. In reality, temporary dumping ground had started in the ground since April 2025 only. Before that, the dumping ground was near Ras Mandir and Satsang Kendra Hauli, where the waste of the old ground was completely remediated and cleared under the project called an NESIDS. The deponent further states that the petitioners are well aware about setting up of the project and that in the aforesaid site, but they are trying to mislead the Honorable Court by mentioning that the same as an unscientific and illegal dumping ground. Also, the petitioners created barrier by blocking roads to resist carrying the construction material for the proposed material recovery facility and composite pit project.
And what have they said?
They said that that is a dumping ground and that will spoil the entire area. And it is near the mandir and the school. And kindly come to para 14 of our affidavit, page 63. But we said that while denying the statements made by the petitioners, beg to state that the art filling is done in the area before waste is accumulated. Moreover, the petitioners blocked the road, preventing construction material to reach the site for construction of the boundary wall, as well as art filling for their vested interest. As in case of leachate spread out, the designated land will not be treated as a sanitary landfill facility, but an MRF facility is going to be established where appropriate construction will be done so that no pollution or similar issue occurred in future, which may be hazardous to human health.
These are all things which you have shown, which you have promised for future.
But in fact,
what's happening now?
In fact, tender has been issued, and while filing this affidavit in the month of September, we said that it is going on. The process is going on.
No, this is a very vague statement, Mr.
No,
Nath. Tell us when would that be completed? That MRF facility, the processing facility.
The up-to-date position, I'll advise the Honorable Court. Malad. It was at that point of time, it was under process. Malad, I'll place the up-to-date position. Malad. Otherwise, Malad, our case is Malad, that it is not a dumping.
Therefore, this appeal is not. I mean, they are not misleading. You know, you admit that temporary dumping had started sometimes in April without making all that arrangement.
Malad, construction was going on for the MRF only for segregation.
What is the stage of construction? Is there any segregating?
That I'll place.
Of course, you have tried to answer.
That I'll place.
But then it's very, very vague.
But
it's absolutely vague.
I respectfully said we have categorically said that it is not a dumping ground.
Look at this now. Your government tries to look at these things not as adversary litigation. We are happy at that. We are happy at it. Now, therefore, the reasoning given by the petitioners is that there is a Namghar, there is a school, there is a hospital. And I don't know whether you have had any occasion to live by the side of a landfill. It's simply impossible. You can't breathe. It's worse than a gas chamber. So unless there is some process made in the middle of the town, you can't have a dumping ground. I mean, that's absolutely, that militates against any civic, facility. But just find out. But then there are units which would segregate the waste. They would compress it, do whatever, and then they convert it into some recyclable things.
Yes. That unit is going on.
No, but what is whether there has been a financial sanction?
Status. I'll place it before your lordship.
Mr. Nath,
lordship.
Senior government advocate. Senior government advocate submits that the detailed affidavit with respect to the construction of the waste. What is construction of MRF facility? A detailed report with respect to the construction of material recovery facility and compost pit would be provided. What have I said? At the site in question shall be provided by the next day. Re-notify 2 weeks, 3 weeks.
Lordship. Their residences are 1 kilometer to 800 meters away.
But you tell us that it has come up, there is a financial sanction. You have started, the brickwork has started, machines have been moved in. We'll be satisfied. Somewhere the waste has to go somewhere.
True.
With the MRF and compost pit facilities, I think their grievances would be redressed. Unless otherwise, they not for nothing they would blockade the road or put up barricade, right?
They may have some apprehension.
That is a rule matters.
They have some apprehension. They have,
Without this PIL also, you're required to do this.
we have done, we have said in the affidavit,
So
I'll
therefore,
I'll-
we need to be satisfied and give us the photographs. We'll be absolutely satisfied. We will not allow Mr. Chaudhary to speak.
True, my lord, true. We'll place. Lord.
Among
In
the
March.
case, but waste, there is a rule, madam. Waste management rule 2016, madam. Everything is there, madam. If they follow the rules, that will do also, madam.
All right, all right.
Obliged to law.
Highly
10th
Madam,
March.
I have date when
in
you give,
three.
madam. Date and date, madam.
Let me give you.
Madam,
10th March.
Obliged, obliged.
Item 20.
Highly obliged.
By the order date itself.
This concerns our employees.
I'm sorry.
So let us hear it sometimes in February. Who wants to file? Mr.
My parents, they said
Mr. Dhar. Mr. Dhar, where is your affidavit? Mr. Dhar, where is your affidavit?
Okay. I have not filed, my lord.
Why?
I
You've taken time in the last occasion.
No, my lord, on last occasion I was directed.
My prayer is that, my lord, matter maybe admit this petition and fix the date in the hearing. In the meantime, he may file. As the Lord, sorry for that. Short date may be given. In the meantime, I'll understand.
Mr. Dhar, learned advocate, correspondent number 3. Seeks further time. No, yes, seeks further time to put in his response to the memo 3. Let that be done by the next date. List this matter on early April.
Much. That is awesome.
7 April. Item 21.
May I please record, my lords?
Yes.
My lords, this is a writ appeal which was transferred to this Honorable High Court by an order of the Honorable Supreme Court, my lords.
All right.
Yes, my lords. My lords, the subject matter of this writ appeal is that, my lords, the appellant is a promotee, and what has happened is that in the vacancy year against which he was supposed to be adjusted, he was adjusted, no doubt, my lords, but direct recruitees who had not become eligible at the time of the convening of the DPC were adjusted in the same vacancy year as the appellant, my lords. Our contention is that they did not become eligible at the time of the convening of the DPC. Therefore, they became eligible. They would become eligible for the next vacancy year. That is 2020, 2021, but they have been adjusted against the vacancies arising in the vacancy year 2019, 2020. my lord.
I believe the appellant has now been promoted.
Yes, my lords,
to the
but
post
the
of
yes, my lords, the only form at this point,
how does this litigation affect you in future?
my lords, the direct
And
recruitees.
you've been given that seniority also.
No, my lords, that is the only qualm that we have, that the direct recruitees, they sit above us, above me and all the other promotees as well.
Yes, who appears for the respondent?
My lord, I am for the respondent number 5. My lord, yesterday we have lead by senior advocate Momota Devi Oinam. And yesterday we have filed a Vakalatnama, and another date may be fixed. In the meantime, senior mayor will appear.
You are appearing for respondent.
Respondent number 5. Respondent number 4, your lordship.
Respondent number 4.
Yes, your
And other respondents?
other respondents are.
My lords, I had informed them about today's hearing.
Yes, we had requested you to inform, but nobody has filed their Vakalatnama except him. So what is your name, Mr. Counsel?
Myself and annexing.
Mr. Singh, can you contact the others also?
Yes, I will do my best.
They're all
Yes.
direct recruits.
They are from all Manipur councils.
So they have to be here.
Yes,
I mean, they have to be represented.
yes, correct.
So, but Mr. Gogoi, did you inform them?
Yes, my lords, I informed them here in Manipur.
I have addressed you seeing the name in the order sheet.
My lords, Mr. Gogoi happens to be the local counsel, my lords. I am here in Manipur, my lord.
All right, all right. So, Mr. Singh,
Yes, Your Honor.
it is your responsibility.
Yes, yes, I'll take the full responsibility, Your Lordship.
It appears, Mr. So-and-so Singh appears for respondent number 4, who seeks some time to file a response to the memo of appeal. Mr. Singh has also assured this court that he shall intimate other respondents. Has notice been issued?
Yes, my lords. It was at the final hearing stage before the Honorable High Court of Manipur.
Other respondents for their representation to contest this litigation, if so desired. They let these set of appeals. There are many, no? Let these set of let this appeal be listed along with all interlocutory applications for final hearing on. We give a date in April, Mr. Sahu.
If possible, February. I was praying
You are already an executive engineer. There is no urgency. Just see seniority between two sets of people. Anyway, we give it in first week of April.
If possible, my lords, a small prayer in March, my lord. Any date in March.
March, the calendar is full. Let's keep it immediately after. We'll keep it on 6th of April.
6th of April. My lords. And my lords, my name may kindly be recorded, my lords, in the order.
Upar Velingara, Mr. Sahu.
Yes, sir. Obliged.
Deeply obliged. my lords.
Item 22.
Yes.
Lordship, pursuant to the order at 5/12/2025, Lordship, where again we are released. We have preferred a writ petition, namely WBC 6580 of 2025, Lordship. That matter is listed tomorrow, Lordship. So may I pray the matter may come up after any day after 22nd, Your Lordship.
Yes, but we got disoriented. What is the matter?
Matter is regarding two drug inspectors. They were working as 3F under regulation 3F. These are temporary posts, Lordship.
For Assam Public Service.
Assam Public 951, yes. And they wanted regularization.
Where there is no need for any formality of.
No formal. For 4 months and subsequently it has to be extended from time to time.
This was
And when regular appointment is preferred, they can participate.
Okay.
So they sought regulation, which was denied. And we have already discharged because we have conducted 3-4 rounds of recruitment process, which they have never participated. Now they want regularization.
And it was open for them.
It was open for them. They deliberately did not participate.
We become overage during the process.
Why? This is only an interim measure, no? Under the 3F.
Yes, the law is very clear, Lordship. And there are series of cases from 1988 onwards. The division bench has very clearly taken the stand.
What do you want, Mr.?
The writ petition is listed tomorrow, Your Lordship.
Which writ petition?
Where we have challenged the subsequent.
In the order, there is a direction that we can pass a speaking order, whether we want to continue them or not. So we pass a speaking order not to continue them. They have challenged it before the learned single judge, which is listed tomorrow.
Listed tomorrow, so we'll keep it after 1 week.
Lordship.
As prayed for on behalf of the appellant, let this matter come up. Now you're officiating. You're working or you're out?
As of the Lordship, we handed over.
So April.
Highly obliged.
Lordship, liberty will be granted for us to make a mention, Lordship.
Have we ever stopped mentioning
Lordship.
without the liberty?
Lordship.
8 April.
Lordship.
Item 23.
May it please your lordship.
Yes.
I appear for Oil India. There's an application filed seeking vacation of an interim order passed by your lordship on 7th of December 2020, my lords. Whereby, my lords, the EC is dated 11/5/2020. There was a condition, my lords, that the Oil India, my lords, had to carry out the biodiversity impacts the assessment study
Just a
through
minute,
the
Mr. Goswami, we will like to see the order dated 7/12/2020.
Fine, that your lordship will find at page 58 and 61, 62 is the relevant part. If your lordship sees in the middle, my lords, as your lordship so pleases.
In this IA, where do
My
we
lords,
get it?
my lords, page 58, the order starts. The relevant part is at page 61.
1 second.
My lords.
So that impact assessment has been done.
Because I must tell your lordships fairly, my lords, the final technical report, your lordship will find at page 77 to 396. It was carried out in July 2023. Now, there is, my lords, the conclude that the biodiversity impact is high, but they have suggested mitigating measures, which we have to comply. If your lordship just have a look at page 390, the conclusion, 397. Sorry, madam, 387 is the conclusion, and the relevant part your lordship will find at foot of page 389. If your lordship just have a look at 389, foot of the page. my lord, has as 3 of the identified risks, my lord, has that.
Yes.
My lord, so risk impact 10, 15, and 19
16.
fall in the severe. 16, my lords, fall in the severe category in the biodiversity risk matrix in case of extreme events such as blowouts, as 4 of the identified risk impact number 23, 24, 26, and 29 fall in severe category in the biodiversity risk matrix along with the above mentioned 3 impacts. It can be concluded that overall risk for the study on biodiversity is high. This is without the mitigating features that your lordship will find at page 97. Before I show your lordship the mitigating.
397.
No, sir, it's page 97. Page 97. The same thing is in the summary also mentioned at 97. And I just want to read the last 2 lines.
Yeah.
The above part is what I have already read, my lords. With the implementation of the actions in the management plan recommended, the anticipated impacts can be minimized. Now, the management plan your lordship will find at page 390. My lords, against each impact, they have recommended actions in the right-hand side, if your lordship notices.
So you would
We have to adhere to it.
No. You have to adhere to it not as a prophylactic measure, but to adhere to it before starting oil exploration.
My lord, some measures have to be done before starting, some during the process.
There are only few, it appears. Cursorily, we have seen construction of a green wall.
That has to be done before, my lords.
That has been done.
No, my lords, we have to do it, my lords.
Now do it and then seek our approval.
There's 2 things, my lords, before. The reason why we have moved the application for vacation after 6 years is, my lords, because of because these are forest land. The state sought, my lords, prior consent which is required under 212 from the central government for diversion for non-forest use. Initially, my lords, on 4/7/2024 at 398, that was rejected, my lords. Then, my lords, again it was mooted, my lords. And if your lordship just have a look, the limited purpose for which now the permission is allowed, your lordship will see that at 27/1/2025, that starts at 409.
Now, where is it?
409, my lords, it starts because it deals with many projects. For our purpose, the relevant part is 452, my lord. It gives the entire history your lordship will appreciate. 452, and that has happened on 27th of January 25. It starts at 409 and the relevant part is 452, my lord. It is only for research and development, my lord. Agenda number 4. May I read, my lords?
Yes.
Request for approval to conduct research and development drilling activity to assess the impact of extended reach drilling. This is the new technology, my lords. Without commercial implication regarding so-and-so. The policy agenda item was considered by the advisory committee, that is, my lord, the Forest Advisory Committee, in its meeting dated so-and-so.
There's
My
no
lord.
one to assess. This is unbelievable.
Should I read only the relevant part, my lords?
Right paper. Sit down and.
The para 3, my lords, may I read, my lords? The committee, after deliberation, noted the following. The Secretary, Director General Hydrocarbon, Ministry of Petroleum and Natural Gas, while is DO dated so-and-so, adverting to the minutes of meeting held on so-and-so under the chairmanship of Director General Forest and Special Secretary to decide one suitable location for research and development study to be conducted by WII is, my lord, Wildlife Institute of India, that's the Government of India autonomous body. To decide one suitable location for R&D study to be conducted by WII has requested this ministry to accord approval for carrying out drilling as a research and development activity without any implication, bypassing the online route. Following submissions were made by the Secretary Director General Hydrocarbon under so-and-so, my lords. Your lordship may see, my lords, Roman 4 at 453. WII has been awarded with a long-term research and development project spanning 5 years with a milestone of completing one study in a designated region with a 1-year time frame. The job order with necessary funds for the first study in Northeast region has already been awarded, and the project being as per the agreement has been started.
हमको ये बताइए where is that order? Okay. Is that clear?
It is for only limited.
One second,
My lords, my lords.
1 second, Mr. Baswan.
My lords, I'm sorry, my lords.
Yeah, page 61.
Where is the 4724 का file?
Carrying out.
Yes. 4724. Yeah, in there. 4724 का है क्या? ये वाला? G page 30. 30. Inside the petition, they have an next step.
Approval for undertaking drilling. Now please come to page 458.
50, my lord. My lord, that is true. That is pursuant to the advisory committee. The central government has accorded approval subject to the condition of biodiversity. My lord, this is the final approval by the MOUF.
Okay.
This is if your lordship sees the middle based on the recommendation of the advisory committee, which I was reading, my lords, and that relevant part at 455 is the ultimate decision of the advisory committee.
Why had the approved site?
In the same, my lords.
Okay.
4 locations.
There would be no drilling for commercial purposes now.
Yeah,
It's
lordship, we'll have to adhere to it, my lords. There is no, my lords, and it's only for R&D. It will be done by WII. And your lordship would just see the decision of the advisory committee at 455 after the negation.
What do you say, Mr. Chaudhary?
Lordships, 2 things. Number 1, the IUCN report, which they are talking about as a deliverable 6, which has been annexed to this application, needs to be placed before the expert appraisal committee before it is accepted. And only thereafter, after their approval, can it be only by the acceptance of oil and the ASBB accepting.
Follow,
Not,
what are you saying?
Lordships, the IUCN report, which they have annexed as an deliverable 6. This is deliverable 6, which they have annexed before your lordships. In this petition, in this IA, this needs to be placed before the expert appraisal committee. If I may just take your lordships to the PIL, the body of the PIL. If your lordships will kindly take up the PIL for a moment. At page, it starts at page 76, annexure D. This is the initial notification of 2006. What does the notification say? It says that there are 4 stages of a proposal. Number 1 is screening, then there is scoping, then there's public consultation, and then there is appraisal. So the appraisal stage comes after a biodiversity impact assessment study has been conducted. Thereafter, it has to be appraised by the EAC, by the expert appraisal committee. So this report needs to be placed before the AAC, before they can say
Ms. Chaudhary, you're right, but that's for proper drilling for commercial purposes.
Correct.
This is
That was
R&D.
the-
This is part of, this is a stage anterior to appraisal. See, they give,
no, your lord,
look at this.
Lordships.
Now, the government has given a clearance for R&D. Now, let us understand it in simple terms. The government has given a clearance.
Lordships.
This has not been done because of the stay, of the environmental clearance, subject to, any change or modification or rescission, what would be deemed necessary for a period of time. Now, this R&D study only, for that they have to go for extended reach drilling. There's a new technology which they have to do.
Correct,
But these things. So, is it required to be placed before the appraisal committee?
Your Lordship, the point remains that in the PIL, this was never a subject matter because of the fact that this is a proposal which has come in only in the year 2022.
No, that's right.
So therefore, I'm not sure why my learned friend is trying to club both the issues together because yes, there is an interim order by this honorable court, but it is in respect of the 7 hydrocarbon projects which were projected to be drilled in through the ERD technology.
He's not conflating these two issues. Now, it's different. If you read the order.
Yes, Your Lord. It is.
If you read the order of this court.
Lordships.
That's with respect to commercial exploration.
Correct, Your Lordships.
It is not with respect to R&D.
R&D, yes, Your Lord.
For R&D, unfortunately or fortunately, they have to go for that extended drilling thing in the water.
It is for even for the other 7 hydrocarbon projects which were proposed to be done.
Now we are here for 4 locations located inside Dibru-Saikhowa National Park.
Correct, Your Lordships. But
so if they give this guarantee, now how do you say that this approval also has to undergo the rigors? It has to cross the ringer of appraisal committee.
Lordships, in my respectful submission, that would have been evident from the EAC, from the notification of 2006.
Have you responded to this?
I have filed my objection to it, yes, Your Lordships.
What objection?
I filed an objection to the IA, Lordship, saying that the interim order not to be vacated. The entire matter will be heard at length, considering the fact that the pleadings are otherwise complete.
See, we can look at this.
Lordships.
Forests have to be preserved.
Definitely.
No question.
No question.
Nobody on this earth can stop that now, especially with this kind of consciousness that has developed and the necessity also. But then research also is necessary, no? Oil also is necessary. So therefore, if the forest cover is not disturbed, there is no diversion of forest land.
Lordships will kindly see the report itself, which they have annexed. Everywhere in the report, if you also will see impact 10, 15, 16, 23, 25, 26, 29, everywhere, the impact is in the severe category, Lordships.
So that's right.
Right. And my learned friend has very fairly pointed out that the impact is severe. And so therefore, if one or more of risks are critical or severe, then the overall risk they have themselves identified it as very high. So naturally, oil will have to comply with a lot many things before they are actually given permission.
For research and development, what do you say? For R&D.
But they will still be doing
we would be thinking 500 times
correct
before asking them to explore oil commercially. 500 times.
Right.
But then for research work, can it not be done? That's what you were required to respond to.
I have, Your Lordships. I have responded to that. And I have said that in my humble understanding, this ought to have been placed. If they are taking the help of this particular report.
Before that committee?
That's yes, Your Lordship.
What is that committee?
Expert Appraisal Committee, Your Lordships, which is.
Expert Appraisal Committee.
Yes.
But I suppose this approval is by the experts, no?
No, this is no, Your Lordship. This is a report which has been made. It was a tripartite agreement between Oil India Limited, the Assam State Biodiversity Board, as well as IUCN. It is the international. I forget the full form of this, but it's a private agency. So there was a tripartite agreement between these 3 authorities, and the IUCN was the one which conducted the entire biodiversity impact assessment report, and they have now placed it as a deliverable 6. Deliverable 7 is an audiovisual report which they have also submitted along with it. Now, deliverable 6 is what has been annexed in this particular application before Your Lordships, this entire report. And that is exactly what I was trying to tell Your Lordships, that this entire report itself talks about the severe impact which any activity in the park might have. The impact assessment is there before Your Lordships. Now, if Your Lordships will collate with this.
We have followed all these
Yes. Deliverable 6.
But whether this. No. but this, see, there is a PRD exercise for the purposes of,
If I may just take your lordship to the body of the PIL for one moment, if your lordship will kindly bear with me for a minute.
read that.
Lordships, at page 84 of the PIL, it starts at page 83. It is called, if I may again reiterate, that there are 4 stages of a project. One is
That is what we are telling you every now and then.
Yes, sir.
The 4 stages would come when they seek permission for exploration of oil on a commercial basis. Study, suppose a reserve forest.
Correct.
Now, if somebody wants to see the biodiversity, wants to go, wants to study, wants to see the avian population, I don't think
They are not going there to study the avian population. Your
Yeah,
lordship. We are all aware
I've
of that.
given you an example.
Your lordship.
So that way, the research work, they were definitely not. Oil India is
They're
not
not going there for
They're
avian.
interested in oil. They're not in
Yes, your lordship.
aviatory, number.
If only.
But then this is a research work. And I think that the order that they want to be not rescinded, but clarified, that says it's only for production, it's not for research.
For extension, drilling and testing, your lordship. That is correct. The order says,
And therefore,
as long as your lordship modifies the order to the extent.
They ought not to have come here for this. If it is only research, nothing is required.
Because perhaps because the PIL is pending before your lordships, which is a very fair thing we had to have done. As long as your lordship modifies the order to the extent that it is only for the purpose of research and development, and also that the impacts.
That is the only thing which Mr. Goswami has been speaking
My lord,
for all this
right,
time.
absolutely, my lord.
Then in that case, your lordship would perhaps deal with the matter as your lordship deems fit and fix the entire matter for hearing at a subsequent stage when we can discuss the entire.
Let them carry on their research work. Research should not be
Research,
stopped.
yes.
It's as important as maintaining forest.
The approval order file, fresh proposal for.
Yes, Mr. Chaudhary.
Now this, your lordship will come to.
No, but we will come to everything. We'll see this. But only for research, I don't think it's not. I'm not seeing any red flag here.
If lordship thinks it otherwise, then there will be no research in the country.
No, that's what.
And
no,
As long as they comply with the directions which have been issued at page 455 of the IA, there will be compliance of those.
We'll do that.
definitely they will.
We'll very carefully employ our words so that Mr. Goswami does not go about drilling and then through backdoor he would start exploring it without letting us know.
Ultimately, this is not an adversarial litigation in that
Perhaps
sense.
being a public sector undertaking, he won't take the risk.
No, you don't know. You really don't know. I have only recently visited that place. The tranquility was simply charming. I would be the last person to sort of say that anything should be done there. While you're boating in that river body, you hear only the sound of that, the roar, nothing else, and the chirping of the birds.
Perhaps nearby there is the Maguri Bill lordship has visited. That's very enchanting.
Very enchanting. Nonetheless, we'll give that permission for research work. And we'll make that modification in the order, but we will couch it in very strict terms so that it's not misunderstood. Or it does not give a license for any further thing until the time we hear this application. We'll choose our words very carefully, and that we will say. You just give the paragraphs, Mr. Goswami, any local council here.
Yes, my lord, Mr. Kunal is.
You tell him to just mark the.
I'll do that.
Flag the pages that you have referred to us.
Right away.
Today.
Yes, my lord.
Pass an order.
Do it, ma'am.
Application. We'll say application stands allowed. We'll incorporate everything so that it is not misunderstood. It is not vague. And it shall be very, very clear with respect to the ambit of our concession.
Lordships, my objection is it's very small document and everything is dealt with over here itself. Your Lordships may kindly quote our
Mark the
defense
paragraph, madam.
from here itself. Yes, I'll mark the passage.
ये हमारे पास हाँ आइए अल्लाह
Deeply obliged, my lords, deeply obliged.
rest के लिए we'll give a time. They allow this आइए
I'm
in a limited way.
Yes,
Deeply
I'm
obliged.
deeply obliged.
इसको हमारे साथ देना. Please mark all
Yes,
those
I
things.
will. I will. हमारा जो पैराग्राफ है ना, ये काम objection था, that's smarter.
Date to date, you know? Date in March. 25th March.
Mr. Chaudhary will dictate the orders today, so you please mark it, and Mr. Goswami Junior also will mark.
Item 24.
Yes.
My President, this matter pertains to, they were serving as well as the Lordship, your Lordship order dated 15/10/2025. The promotional revenue which was available to them was entirely curtailed off, and they were left with no promotional revenues for the rest of their service tenure. Now, Lordship, on the last occasion, my learned senior had submitted that the authorities have taken up the matter and they are in the process of providing promotional revenues. And the status report was required.
Lordship,
Yes, Mr. Chair.
Lordship, in fact,
The ball is in your court.
yes, Lordship. In fact, Lordship, a draft rule has been already prepared, Lordship, and it is circulated. Now it is for the approval of the ministry, Lordship. That may take some time because the stakeholders have to be heard. But it is in the process, Lordship. And the promotional avenues have been defined. So I will furnish him with a copy, Lordship.
Mr. R.K.D. Chaudhary, learned deputy solicitor, learned deputy SGI, has placed before this court a draft rule proposing amendment plus revision of existing recruitment rules of charge mechanic / equipment mechanic, bracket mechanical, by expanding the feeder cadre of promotion with the posts of turner, welder, and machinist. For the draft rule to be finalized, the same has to have the approval at many levels, and the stakeholders also are required to give their response. This would take some time. Mr. Chaudhary therefore submits that that this case be adjourned for some time, by which date the service rules would be complete. Service rules would be formulated, which would immensely benefit the charge mechanics and the grievances of the petitioner. The grievance of the petitioner would be substantially redressed. This matter sometimes in May.
Report me. Supplementary list, item 31 for admission.
Yes, sir. 27 to be.
May I please? My lord, the issue of this matter is all pending, my lord, before the Honorable Supreme Court, my lord. And matter is admitted for hearing. So, my lord, after.
For the reason of the SLA number 30056 of 2017, pending adjudication before the Supreme Court, this case is adjourned to. We have date in April.
22nd April. Item 32 to 36.
Merci, Your Lordships. You'll have to remind us. That day you had argued, but then we have forgotten.
My lords, may I just, the short issue here, my lords, is there are mining leases, that is applications for mining leases where there's been a grant order under 10A2B, section 10A2B of the MMDR Act, in which, my lords, there is a
Mr. Krishnan, for some reason, we would take a leave of 5 minutes. We'll come back again.
My lords, may I just suggest this, my lords? In respect of this very issue, there is a batch of petitions which is coming up for hearing starting January 28th and February 4th. My lords, concerning the constitutional validity of the 2021 amendment to section 10A2B.
Okay.
Therefore, in the Supreme Court.
Naturally, Supreme Court.
Yes. Yes, my lords.
So we adjourn it thereafter.
If your lordships can take it up in March, my lords, we'd be grateful. By then, we would have a very good idea of what is the situation.
Early April?
Very well, my lords. Early April, my lords. Very well.
Before the other Bihu, fixed date commences.
Yes, my
We
lords.
have 2 Bihu holidays here.
Oh, very well, my lords. I
7 days,
understand.
8 days. Therefore, the expression on your face, I mean, that made me understand that you do not know. I was also
I was not aware, but I can understand Bihu holidays, my lords, because we have a similar.
very long holidays, 2 long
Yes,
holidays.
in South India and Kerala, we have holidays around the same time. Though I was born and brought up in Madras, by ancestry I'm from Kerala, and they have Vishu, which is the same as Bihu, my lords.
So we adjourn it for, we say 6th of April.
Most grateful, my lords.
Let all these matters come up for consideration on 6th of April.
Most grateful, my lords.
6 is a Monday, sir.
My lords, could it be on the 8th?
Why not?
8th,
8th.
I'd be grateful, my lords.
If you want leisurely time of the court, I think it is Tuesdays and Thursdays. These are hearing days. We can hear it as hearing.
Thursday, the 9th, my lords.
9th.
Most grateful, my lords. Most grateful.
All right, we'll come back in 5 minutes.
Daily list for hearing, item 27 and 28.
I'm for item 28, my lord.
Yes.
My brother is for 27.
You argue, sir. No, you argue, sir.
My lord, there is a case, my lord. I may lead item 28, my lord. Well, basically, my 2028,
You're in 28.
my lord.
Yes.
My lord, there is a case, my lord. In 2022, to reduce the burden of PT cases, my lord, a notification was issued by the government of Assam, my lord. Now, while issuance of this notification, they have also laid down the SOP that in what process this decision can be implemented in letter and spirit, my lord. But what happened, my lord, after passing of this notification, it is seen that the thing which is required to be executed in real terms, my lord, that has not been followed up in, and thereafter, my lord, the cases are pending from year to year, my lord. My lord, I have applied for RTI information, and while I got the information from the different district, which is one of the part of record says that still there are lots of cases pending, which come under the zone of 3 years punishment, and that has required to be dealt with under the notification. The lack of coordination between the public prosecutor, informations, or my lord, court, or my lord, the judicial department, or my lord, the SOP which has been also directed to the Registrar General of Guwahati High Court to deal with the subject matter in proper manner, my lord, that has not been followed. My view is that, my lord, still today, even, my lord, there's the 2022 notification, which has to be acted upon in, my lord, the real terms, that has not been followed up, my lord, out of which, my lord, that cases are still pending, my lord. Therefore, my lord, on last occasion, I have been directed to put a suggestion, my lord, before this honorable court, that in what manner, my lord, this notification can be implemented. My lord, I have also submitted the suggestions, my lord, in my view, my lord, that required consideration, my lord. The SOP, my lord, covers in page 25, my lord.
Page 25.
Page 45.
25, my lord.
ये क्यों है वही है Page 45. You want you to listen?
My lord, the earlier occasion I have been directed, I have placed, and if Roshi, I have the copy also, my lord.
Okay, yes.
What are we doing? Mr. Chamaria, it calls for an administrative shake-up,
Right.
which we have been able to do to a large extent.
Right.
But then passing a judicial order here would further complicate the issue.
My lord, may I suggest this?
We have taken your suggestions. Those are good suggestions. In
Right.
fact, if you're aware, you may not be aware.
Right.
From that side, you would not know what we have been doing, but we are exactly following the same system
Yes,
as you have suggested.
yes, no doubt. But Lord, see what happened, there is no any uniform pattern which has been for all district. My lord.
No,
we,
but
we also appeared in some cases, we found that difficulty, my lord. In some cases where we personally appeared, we found the same difficulty, my lord. Therefore, this is the illustration which has happened. Somewhere it is disposed of,
something else.
Somewhere it has not been disposed of. Now, Lordship,
Who represents the Registrar General? Where is Mr. Das?
It's a petition let.
We need to tell him certain things. Mr. Chamaria, we are very clear. We are not passing.
No, but no.
So far as your suggestions are
Yes,
concerned, we'll
no
dispose
problem.
of this.
We want
this
implementation.
petition.
No problem. At all.
It's something, I wouldn't say it is an eye opener, but I would definitely say that it gives us a good, passage forward.
Yes,
We'll take it into account, no difficulty.
no problem.
But putting it in.
No problem. My object, Lordship, we have to reach the object, my lord.
It'll be problematic, and then judicial order has to be followed, and then any breach which is not generally causing any difficulty, that also.
Lordship, my lord, Lordship may apply its own wisdom, my lord. Whatever the object is that, my lord, it has to be
We
implemented.
have seen your suggestions are good, your concern is good, we can see this.
Yes, ma'am.
Let me ask Mr. Das to be anytime here, if not today only. We adjourn the matter. Ask him to be here, that we'll say, and we'll also talk to the Registrar General. We'll have it formalized in the.
Yes, absolutely. That uniform
I think
pattern.
that satisfy you.
Quite right, ma'am.
And that'll be good for us also, for our judicial
My
administration.
lord, I just want one thing. In my lord, remote areas, more some subdivisions are there. Where my lord, what happened? The litigants are very, my lord, like poor, my lord, farmers, etc. They do not know the procedure that even they are.
Mr. Das.
I'm sorry.
You go through the suggestions given by Mr. Chamaria once again.
Yes.
You may have gone through it, but you go through it again.
Yes.
We are following the same procedure.
Yes.
Right. Now, something which can be suggested, this is, we have told him that we are not going to pass any order judicially saying that these are the steps to be taken. Definitely not, because that will create further bottlenecks.
For the chaos, yes.
So we will instruct the Registrar General, and maybe in the administrative side, we will ask the Registrar General to come out with
That's
a
good.
kind of SOP.
Correct, my lord. Correct. Very good.
So you go through it.
Yes, my lord.
We are keeping it to another date.
Fine.
You can have a meeting with the Registrar General.
Yes, my lord. I'll have.
We are looking at it from our own, revamping, for our own revamping of our own internal mechanism.
It's not adversarial. It's
No.
It will be beneficial for all of us.
We are very happy that
Yes.
see this petition.
Yes.
So you also talk to him.
Yes.
And show him this suggestion.
Yes.
I will also tell him.
Fine.
I'll tell him in the administrative side, but you say that he has to respond.
Yes.
And then we'll come out with an SOP, which will not be for the consumption of others.
Yes.
It'll be for the registry to ensure that this is the way in which we have to proceed.
Fine, man.
Correct. So go through it. We are keeping it for another day.
Fine, man.
Have a meeting with him.
Yes, man.
Have you given him a copy?
Yes.
He must
Yes.
be
Yes. Right.
Yes.
SOP is there. Man. SOP is. Fine.
I think we are following the same system, aren't we?
Yes.
The thing is going on.
More or less, my lord, we are following this. I have previously I have
You
seen.
please talk to
Let me
him.
get the data
again,
first, man.
I'll again have a talk with him. We'll also try if something more can be added or some, my lord.
My lord, may I suggest only one thing, my lord? That the data, update data is very necessary, my lord. If possible to procure from, my lord, the respective district.
That is
Because this is the data which I have.
I said no. We have a system called National Judicial Data Grid.
Yes, my lord. It's
Everything
already-
is available.
Yes.
In fact, it is good enough data mined.
Right.
Whatever measures we are taking in the administrative side, that is on the basis of the
Data available.
uploaded information on NJ, National Judicial Data, NJDG.
Lord, so far as my limited knowledge goes, now if a learned judge does cross-examine in three cases, in the evening, that has to be uploaded.
Oh, this reminds me, we don't have Assam High Court does not have a judicial clock, no?
No, we have it. It's there in the website.
We can access this in our
Yes, sir,
Telegram
that is-
channel. There is a
exactly.
Specific.
No, do we have a big judicial clock?
Yes, it's where on in front of. I put up many.
No, here it is there. I would like to see today. I would like to see today.
Big screen.
Big screen is there, my lord, outside.
Now, if it is properly updated, an onlooker can find how many judges are present today,
My lord.
how many courts are running at the moment, which judge is absent,
Yes, sir. Yes,
what is the number of chairs in the court halls. These all details are there, and it crosses through the screen for all districts. So this data and all, you don't bother. That's we have done lots about it.
About this, my lord, categories cases, that is specifically suppose segregated, my lord, that within this 3 years category, how much disposal pending, my lord, in the light of this notification, then
That we have a list. We have a
yes. Now, second problem, my lord, just because this is also relevant, my lord, the uploading of the, my lord, orders of the Lord Judiciary, my lord. No doubt, my lord, certain, my lord, direction.
Every day it has to be uploaded.
No, my lord, it is not realism, my lord, we are facing that problem, my lord, still.
Yeah.
There are a lot of direction given despite of that, my lord.
We'll do that.
Yes.
I would shortly, with my brother judges, I'll be shortly having a conference, video conference with all the district judges.
Yes.
It has to be a repeated exercise. Now they are under an obligation to upload it by the end of
Yes,
the day.
yes, there are a lot of direction given from the registry, my lord, but despite of that, practically, my lord, what I feel, my lord.
We'll see. We'll see. Now, for the moment, we are adjourning
Yes,
the matter.
yes.
Let us, you please have a talk.
Yes, ma'am.
While pressing the petition, Mr. Sandeep Chamaria, learned advocate, Mr. Sandeep Chamaria, learned advocate, has given some suggestions for early disposal of criminal cases where punishment is, where the maximum punishment is 3 years. Mr. H.K. Das, learned advocate, appearing in the High Court / Registrar General, submits that he shall confer with the Registrar General of Guwahati High Court, and shall come back to this court with specific information whether the suggestions given by Mr. Chamaria are being followed as followed, and whether any further course correction is required for weeding out any systemic delay in disposal of cases.
My lord.
List this matter under the same heading on. Give a date in April. Post view.
Well,
21-4.
highly obliged.
27?
20.
No, the matter was a bit different. My lord, our item was stacked together, but it was a different, sir. My lord, my issue was in regard to the forming rules for seeking adjournment and uploading of the order. So in that matter, this was stacked together.
So otherwise also we'll see that.
Obliged, sir.
What rules of adjournment?
My lord, the issue is like in the lower judiciary, on a drop of hat, adjournments are granted, more than 3 adjournments are granted without following the due procedure and rules as mentioned.
See that. Will you refer to that also with the rest? All right.
Obliged.
Highly obliged.
Supplementary list, item 37 to 39 for hearing.
May I please your lordship, my lord, before my learned senior colleague begins, my lord, with all sincere apology, my lord, we had filed an affidavit pursuant to my lord's order, bringing on record certain vital documents. That affidavit was filed on last 19th of January. Unfortunately, it has not come on record.
You have mentioned it in the
My
morning,
lord,
we could
my
have
lord,
fetched it.
My lord, that
Just
is-
I can just give a reply. The report, they have served the copy to us yesterday. What I felt that, subject to your lordship will look into it, that may not be relevant so for adjudication of this matter, Inspector. That's what I have checked it, my lord. That means your lordship can look into it, but because your lordship will definitely look into it. The 3 things which your lordship, your honorable Chief Justice has raised, I just noted when he left the court on 27/11/2025. One, what is the present status of judgment passed by the Assam Board of Revenue? That was the first issue that was raised. Then now the answer is that this is under challenge in appeal 240 of 2024. That's number 1. Number 2, very pertinent. Whether you have taken the plea in the writ petition number 240, so and so that the learned Assam Board of Revenue exceeded his jurisdiction by deciding the entire 101 bigha, 9 lectures land instead of 17 bighas, 2 kathas, 6 acres, which is subject matter before the learned Assam Board of Revenue. I checked the records of the writ petition. This plea has been specifically been taken at pleaded case at page 110, ground number B and C. So that's the position of the case. And for my lord, these are appeals, 2 big appeals. So I made a note out of it, which consists of only 14 pages. I think overall view with the facts. Yes.
Give it to us.
Yes. Just other side. Other side. Other side.
It is not like that. Would you, Mr. Das, would you require to reply to that, or you say you have
I
said that it
don't,
is not
I
relevant?
not necessarily at the present moment after going through it, my lord.
All right, we have taken it on record.
Yes.
Again. No, notes of argument, we will not take it on record midway. We have
Why- why-
informally, we have unofficially taken it.
No, no, why I have done it? Because
you've rightly
time
done it.
is very precious. So if I start reading the entire, my lord.
That's a very good way to cut short the time.
Yes.
And come to the brass
Is
tacks.
only 14 pages backed by some judgment of the Supreme Court on this point. My lord, 5 judgments. 5 judgments.
My lord, overall, what I have looked into it, subject, your lordship, this second point was very important, relevant, jurisdictional issue. The Assam Board of Revenue, while deciding a revenue, my lord, the jurisdiction of a revenue court, revenue appeal, it is only restricted under Tenancy Act. How can it go beyond that? And a declaration can be made.
Like civil court.
Like a civil court.
Mr. R. Botpuzari, Standing Council Revenue.
Your Lordships, I am on behalf of the, in respect of the appeal number 240. I have something sufficient.
Keep it, we are adjourning the matter for another day.
Is the only thing is it, whether the maintainable or not.
That's right.
Since 2023, the re-appeal is going on. Adjournment. And one, the petition adjournment is 33 times fine.
Mr. Botpuzari, this is directed against you.
33 times adjournment.
Record.
From the face of the.
All right. All right.
I
You see, in the previous, Mr. Counsel, please listen to us. In the previous proceeding, a lawyer wanted this court to formulate certain rules for adjournment. So we are conscious of it. On next day, we will deal with this situation.
But the matter is in respect of the biodiversity chapter. That is chapter has been decided by the administrative tribunal, Board of Revenue, the Government of Legislation, Government of Assam, as well as by the Honorable High Court decision. The High Court is not in the appellate court to go through the landlord and tenancy. They have come as a tenant before the Honorable. In respect of the, that is my lord, that is by way of the reader. My humble and respectful submission, High Judges 1952 my lord, has been passed. The reader is not applicable at all.
All right. Mr. R. Botpuzari, Standing Council Revenue Department submits that affidavit. That the response affidavit has been filed on 19th of January.
In writ appeal number 43 of 24.
In writ appeal number 43 of 2020.
My lord.
However, the same is not on record. Let the same be placed on record. Mr. Digant Das, the NCP advocate, has also filed 2 copies of short notes about the background facts of the case. Let that also be taken on record. List this matter for consideration on sometimes on 20th or 21st or 22nd of April.
Before that, it should be done like February itself.
February, it will not be possible.
February possible or March, somewhere in the month of March.
It'll take some time. We will also go through it. But we will finally decide the issue. We'll keep it on some Tuesday.
Yes.
So that we have plenty of time. Tuesday or Thursday, depending on your availability.
That's it.
Huh?
Can it be in the month of February with all respect?
Let's keep it on Thursday, 26th of March. 26th of March.
The final hearing, the final hearing, or it will take another date after that.
Can we promise for something which is in distant past?
I don't understand. My London friend, he's my friend. He's very senior to us also. He's too contemporary. Nothing should be emotionally taken before the court. These are our clients, his clients.
Mr. Das,
don't take it emotional.
Rest assured, because this court,
I know.
especially me, I have experienced at dealing with such Emotionally surcharged arguments.
So-
I come from that
So,
part. of the
I
country.
know, my lord.
But the difficulty is this. Now, this would make him disoriented in making his submission.
Sir, my lord, just 2 minutes, I'm just wasting your time.
No.
Just 85, I joined this profession. My uncle, he's no more, he's one of the best lawyer in criminal side. He died. My grandfather also, he was a criminal. So 85, I joined this profession. He said that I was not his junior. So my mother was saying, his own brother, why you are top senior lawyer? You should take him as a first case. So this session, he has taken me a session called moving a bail application, 438. Then big lawyer comes before the court and court says, yes, my Chaudhary, what case? No, interim bail. We'll call for the case there. I was really upset. I went, and for 3 days, I was upset. And he called me. Hey, I am looking for last 3 days, you are upset. Why you are so upset? I said, you are a senior lawyer. I thought that some interim protection. Oh, you will not be, he said, you will not be able to practice. First lesson I got, don't identify with the client. You just go to the court, plead whatever you want. It's up to the court will pass an order. So that I have taken in mind. Always I say in the court, although some my juniors who really become excited, I say, don't be excited, it's a court only.
Some bit of excitability is necessary to build up your argument.
No, my lord, what is excitement? Assertiveness is required. Assertiveness, what I feel, my assertiveness is required. But my lord, emotion involvement.